The year was 1991. The Ram Mandir movement was at its peak. The Babri Masjid was still standing, but there were communal tensions all across the country in various parts, including, of course, Uttar Pradesh. There were communal tensions in Gujarat, Karnataka, Andhra Pradesh. And this was when the P.V. Narasimha Rao government brought about a law in the hope that it would prevent any such similar Ram Mandir sort of movement in any other part of the country or across the country. The law, which is called the Places of Worship Act 1991, was brought in with the hope that it would prevent any such dispute about the ownership or the character of any religious place of worship in the country. And this is the law that we'll be talking about in today's episode of Laws of the Land. For this episode, you have me, Apoorva Mandhani, you have Bhadra Sinha for it, and we have with us Supreme Court lawyer Akriti Chaubey, who's fought several cases in the Supreme Court, several prominent ones, including she was a part of the Ram Janmabhoomi Ayodhya Babri Masjid dispute in the Supreme Court. So, of course, she's worked a lot on this law, and which is why she's the best person we could have on this show to talk about this law. Thank you so much for joining us, Akriti.
Thank you so much. I remember her immense contribution in the Ram Janmabhoomi Babri Masjid dispute. So, Akriti, to start with, as Apoorva has pointed out, there was an objective to bring in this law, and the reason was because there was a lot of tension brewing in the country due to the demolition that happened in Ayodhya. So if you could just explain for our viewers what exactly the government at that point of time wanted to do with this law, and how did this idea about having this law came into?
So, if you see the act, it came about before when the Babri Masjid was still standing, all right?
Okay.
So, some of these sections 368 came about in September 1991, rest were enforced prior to that in July 1991. So, at that time, if as you just said, that the Ram Janmabhoomi movement was at its peak and all the 4 suits had been filed, inner courtyard locks had been opened up. And along with that, the then Home Minister Shankar Rao Chavan, when this bill was being discussed and debated in the Lok Sabha, he said that, why we are bringing this bill is because there's a alarming rise in the intolerance. And he said that certain elements in the society who are, propagating this intolerance, one of the methods that they are using to propagate this intolerance is by converting religious places. Okay. And so it's not only, people using it for a political motive. It was also one of the other things which was happening was that because, this political wave was going on. So if I suppose one person is a land grabber, he wants to grab the land of a religious place. He will just grab it, and he knows that political wave is going on. So it's not always a religious motive. But to deter, at a larger extent, of course, the elements in the society who were using it for a religious or a political motive, that, and also for these other instances, small instances, because when the wave comes, it's not only the, the political ones, and even the regular people were getting affected. Okay. So, this was the reason. But, at that time, if you see, Indian Penal Code was already existing. Right. So, in fact, the Supreme Court in the 1994 judgment of Ismail Faruqi, if you read that judgment, and this judgment came about in 1994, and at that time, this Babri Masjid, of course, it had been razed down. So, the Supreme Court noted, and they said that, religion has always been, very important in India, even prior to independence, when Lord Macaulay was framing the Indian Penal Code, when he was drafting this, he inserted a special chapter, chapter 15. And in that section 295 is for this purpose only, which says that, if you are defiling a place of worship, you could be punished. And the Supreme Court actually remarks in that judgment, if the Indian Penal Code could not, stop these people from raising, then little deterrence would be caused by this 1991 Act. Okay. And cut short to today, we are seeing whatever we are seeing.
So are you saying or suggesting that the Places of Worship Act has not been able to achieve the objective for which it was actually brought in?
So actually for so many years, if you see, till the Aodha Judgment came about, Places of Worship Act was sufficient. In fact, if you see, the minor litigation was happening, there was no major event, so to say, and to a large extent, we were able to curb this menace of, forcible conversion of religious places. it is only in the recent time this trend has come about again, and I think now is the true test to find out. I mean, these for certain few years will be very crucial to find out whether it will actually be effective or not.
We will talk about this a little bit later, but just wanted to understand that what exactly does this Places of Worship Act really do? If if you could just explain the law, the
yes.
basic ingredients of the law.
So there are a few. It's a very small act, all right, 8 sections. So section 3 and 4 are the main sections. Section 3 says that a person you cannot convert a place of worship from one religious character to a character of another religion, or even if a place of worship has a certain denomination as a place of worship, you cannot even change it to a character of another denomination within the same religion. All right. So there's a complete bar on that. Now section 4 and places of worship has been defined very widely under section 2C, very widely. It includes almost everything under the sun, all religious places. Then section 4 is sort of puts a cut-off date of 15th August 1947. So it says that you have to basically it seeks to preserve the character of a place of worship as it stood on 15th August 1947. The intention behind this was that independence was a watershed movement. And at that time, India was wanting to heal from the wounds of the past. So whatever had happened before that, there was a cutoff, and after that, whatever character was there, it will remain the same. What section 4 also does is, this act came in 1991. So if any suits or proceedings which are pending at that time relating to such change in character of a religious place, they were also abated. However, there was an exception to that if the change in character, allegation of the change in character came out after 15th August 1947, meaning the actual cause of action arose after 15th August 1947, then then those suits will not abate. Only those suits will survive. However, this provision was, there were several exceptions to which this provision was not applicable. Firstly, the ancient, those places of worship which have, historical importance and they fall under the ancient monuments and archaeological.
The protected monuments, basically.
So under the 1950 Act, if 58 Act, they are protected, they will not be covered by the Places of Worship Act. Then finally, settled and disposed of matters. For instance, even if you see there's a suit filed for a change in the character of place of worship, which had happened before 1947, but before this act came into being, that dispute was either settled or pronounced upon, then that will not be reopened.
So you can't reopen it.
Yes.
Okay.
And then if you have lost the place of worship by experience, by so to say, adverse possession or anything by that, and if your cause of action has already expired by limitation, then of course. And then this next section, section 5, carves out an exception for the Ram Janmabhoomi case.
Why was the Ram Janmabhoomi case made an exception under the law?
So at that time, this suits were already pending.
Okay.
And if you see the preamble of this act, they say that the legislature in its wisdom thought that the Ram Janmabhoomi case was a class of its own. Okay. And a general law cannot be governing that.
So they categorized this particular case as a
class of its own. And that's exactly what the act says.
Okay.
And then section 6 is a punishment, up to 3 years and fine. So it can be 1 to 3 years, anything.
Punishment would mean
if you actually if you're actually converting,
if you try to convert it, or
this act also had an overriding effect over other acts. And section 8 was an interesting one. It inserted an offence, a conviction under the Places of Worship Act under the Representation of Peoples Act. So in the sense that you will get disqualified if you are convicted under this act. Because the start of many of these movements is linked to some sort of political developments. So probably for that reason, the legislature in its wisdom thought that if there's a disqualification issued, then we can nip it in the bud. Probably for that reason.
But isn't it ironical that the Ram Janmabhoomi, the Ram Temple movement actually triggered this act? Is it so? Can we say that?
It was definitely one of the reasons. It was definitely one of the reasons. It finds place in the debates which were happening around this bill at that time.
And despite that, that particular case was kept out of the ambit of this law.
So at that time, I think the government had also given a undertaking to the court that it will not, nothing else will happen. Desecration had happened, but nothing else was happened. This is in 1991. Till that time, the government had also given that, what do you say? They had given their statement to the court that, we will stand as protectors of the mosque. And I think because of the effect that it had on the whole nation at that time, and even because the suits were ongoing, the inner courtyard locks had been opened, I think they thought it in their wisdom that this is something that we cannot touch now, but never again. That's what the legislature thought, never again.
But then you mentioned that it was fulfilling its purpose at least until the Aodha judgment came. This is where we'd like to take the discussion now on what did the Aodha judgment say then that sort of changed the course of the law maybe, and there was a follow-up question on that you can add to that. There was a lot of talk in the Aodha judgment about basic structure as well, and there's been linking about the goal, the aim of this law with the basic structure of the constitution. So if you could clarify that a bit for our viewers as well.
So, firstly, I'd like to clarify that Aodha judgment did not change the tenor of this law at all. All right. Yeah. I think Aodha judgment was another step to say, not anymore. This is the end of it. And if you see, in the judgment when it begins, they list out all the issues, all the four suits ka issues, and then they say that there are certain points of determination which will traverse the gamut of this entire case. That's the exact line used, okay? And they say that these are issues which will, affect every other issue that we are going to decide. And in those issues, they talk about the inscription, and of course, they talk about the Places of Worship Act. So they say that Places of Worship Act was a kind of a guarantee given to all the religions that that after the independence, 15th August 1947, your place of worship will not change. It was a sense of security given to all religions that it will not change. And they say that it was a legislative act to ensure that secular values of Indian polity are maintained. Obviously, polity as well, secularism as well as fraternity, both of these principles are upheld. And both of these principles, as you know, are part of our basic structure. So, the Supreme Court, in fact, went a step ahead and they, quoted the S.R. Bommai judgment, which says that secularism is not only, passive acceptance and tolerance of all religions, but you have to actively give them equal opportunity, equal protection. And this act is a furtherance of that duty being cast upon the legislature, duty being cast upon the government. So it never really actually changed the course of the act. Though, when this Ayodhya matter was being argued, one of the main contentions which Dr. Rajiv Dhawan had taken, and in fact it found a place, I think, in his opening as well as in his closing, if I remember correctly, that if this is allowed day after day, time after time, we will see people coming again and again and saying that there is something under this, dig this up. We will open floodgates of litigation. Right. This was one of the arguments. But of course, to ensure, I think the bench also in their wisdom thought that, the country has suffered enough under this Ram Janmabhoomi dispute and, we should not suffer anymore. Right. And that is why they thought it fit to insert a section on the Places of Worship Act and to say never again. This was another attempt by, the judiciary, apart from the legislature, to say never again.
But the fact that there was a section dedicated to this act. There was, of course, it was mentioned in the Ram Janmabhoomi Babri Masjid dispute judgment. But can you say that mentioning of the act in that judgment means that they're supporting the law? Would it be legally, technically right to say that, or that they have upheld the provisions of the law? Just so that our viewers can understand.
See, upheld the provisions of the law will happen only once it is challenged. Yeah. But they definitely gave it a higher pedestal, and they definitely said that, it is something to enforce the basic foundational features of the constitution, like secularism and fraternity. So definitely they gave so much importance to it, so that, if judiciary even gives a single word about something, it makes a difference, people don't violate it so easily. Okay. So I think it was just a word of caution, and it was also a way of ensuring, because ultimately the Ram Janmabhoomi dispute was what it was, but they wanted to ensure that this should not happen again. And though this act was always there, though IPC provisions were always there, but because so much suffering the nation had gone, and I mean till today the nation is still suffering because of this. So they felt that we need to include this. And they have dedicated a whole section in the judgment. It's not a small portion. They discuss all the sections. They say why all sections. The debates are quoted, and they say why this is of paramount importance. And in my opinion, I mean, I can only guess, but I feel that the bench never wanted the nation to go through something like this again.
So that is the reason why they gave it so much of importance and discussed it at length.
Discussed it and kind of equated it with basic structure.
Right. Spoke about it
in the same breath and said that it is for enforcement of our foundational features of the Constitution.
Right. So now politicians said never again. Courts said wanted it to not happen ever again. But I mean, there are a few district courts, say in the Kashi or Mathura case, that are sort of finding a way around the law, if I may say so, using the exceptions. If you could explain that for our viewers a little bit on how that is happening, how these disputes are still coming up.
So, would you like me to give the facts of both of them and then explain? Or
if you could briefly do it for our viewers, I wouldn't mind that.
So, in the Krishna Janmabhoomi case, what had happened is that in 1967, there was a suit filed by Shri Krishna Janmabhoomi Sangh. Okay. I may not be having the name of the organization correct, but it was some organization which represented itself to be the Krishna Janmabhoomi Trust to the court. It said there's no difference between the Sangh and the trust. And they said that they filed a suit claiming this land. Then this was in 1967. In 1968, they kind of amicably settled the matter. In 68, they even signed a proper settlement before the sub-registrar. Based on this settlement, a compromise was entered into, if I'm not wrong, in 74.
So the compromise was between?
Between the Seva Sangh and the Idgah, Mosque Idgah Trust.
Between both the sides.
Between both the sides. Alright. Now, the present suit which has been filed in 2020, the plaintiffs say that this Sangh was never empowered to enter into that settlement, and they have colluded with the other side and fraudulently conceded this land to the other side, and we want this judgment to be set aside. Alright. Now, if you recall, I just mentioned in section 4, they said whatever has been settled
cannot be reopened.
It doesn't. So the section doesn't say cannot be reopened. It says this act will not apply to those suits which have been settled or decided earlier. So that exception is now being used to say that this was settled earlier. So Places of Worship Act will not apply to it. I mean, even though you definitely as per whatever research I have done and whatever I have studied, I've seen the parliamentary debates also. I feel the intention of putting that clause was to not reopen anything instead of giving people a leeway to open something up. But that's how they have interpreted that, and that's how they have said that this will not apply. Now in the Kashi case, it's something else only. In 1991, what had happened was one party filed a suit. Then that suit kept on lying in limbo after the Aodha Judgment came about. In December 2019, they filed a suit for ASI survey. They filed an application in that 1991 suit for the ASI survey. That application was allowed, ASI survey was ordered, and they also, I think, asked them to stop.
What were they asking in the ASI survey?
Just excavate, and they said that there was a temple earlier, and so on and so forth. And I think that order also stopped prayer, alright, of the Muslim parties. Meanwhile, another suit, this is happening, the Muslim parties are challenging this in the High Court. High Court stays this order. Meanwhile, another suit is filed in 2020. In 2020,
the earlier one is still pending in the High Court. And
earlier one, only this interim order has been challenged. This challenge has been stayed. Meanwhile, another suit is filed in 2020, where they say that we want our right. It's a suit for injunction. They say that right to worship, just like the suit 1 of Ayodhya. They say that we want to worship, and there are deities visible and invisible inside this complex, and we should be given a right to worship. And in that, they filed an application for appointing of a advocate commissioner to just survey the land.
Okay.
That application was allowed ex parte.
Okay.
Against, so
To survey the land.
yeah,
Ex parte,
ex parte meaning without
hearing.
without hearing the other parties, without hearing the Muslim parties in this case. So that application was allowed. And then what happened was, because this order, the ASI order was already stayed. Of course, this, the Muslim parties found out about this suit, and then they filed their objections for recall of that order. Those objections were rejected, and even I think in the second suit of 2020, they also filed an application naming a certain person, that this person should be appointed as the advocate commissioner, and then that objection was also rejected. Then the Muslim parties also filed an order 7 rule 11, which is like for the summary rejection of the plaint, which was also disallowed. Then they went to the High Court. The High Court also disallowed that. Then they went to the Supreme Court. So by that time,
the survey had
ASI survey. So what the stay, when the High Court granted against that ASI order, they said you don't excavate, but you do a survey sort of thing. So by that time, when the matter got ultimately listed, I think on 17th May it got listed before the Supreme Court. On 16th May they found a shivling. So the Supreme Court said that we cannot stop prayers. The Muslim parties will keep on praying, and they protected the shivling which was found. So they tried to balance the rights of both the parties, and they protected the shivling, and that's where we are at now. How the Places of Worship Act doesn't apply.
No, I just want to know one thing, that you said that the plaintiffs had sought permission, or their right to, they wanted to kind of, they were seeking right to worship. Right? So, so now when you are asking for this prayer, so is this an exemption under the Places of Worship Act?
No. There's no exemption for this. So the Places of Worship Act only bars conversion of one religion. Yes.
Yeah.
Now, so
when you are asking for right to worship, does it amount to seeking conversion, or is it only seeking your right to worship?
And under their plaint, I don't have the plaint. I have not read the plaint, but whatever has been reported, based on that, it appears that in their suit they assumed that these deities are already inside. They have said that these visible and invisible deities are already inside this complex, and we need to worship them. Now, of course, the veracity of their allegation has to be tested once the trial happens.
Yes.
But that is, of course, if there are no deities inside, and if the court finds that this is a frivolous complaint, the court will throw it out.
Right.
But of course, the Muslim parties are taking this Places of Worship Act objection also. Now, when this came to the Supreme Court and the Places of Worship Act was cited, this is an oral observation which had fallen from the bench. It doesn't feature in the order. But the bench made a very interesting observation, and going forward, we'll need to see how it plays out. They said that there is a difference between exploration and there's a difference between change in character. So right now, what ASI is doing, what this advocate commissioner would do, whatever, they are all exploring. They are
ascertaining the character of the place.
They are ascertaining. Ascertaining is not changing the character. Someone does a survey on your mosque, it doesn't change the character.
So that is not barred under the law. That is what the court has indicated through its oral observation.
Now, but if you seems like a greyish area, that arguments that can be taken from.
Yeah, exactly. So if you actually see the act, the exception says areas covered. It's used past tense. Covered under the it doesn't say that and of course, if anything, new is found out or anything is not mentioned in the act. Covered, I mean, it appears on a plain reading would mean that something which is already covered. All right. That's what it appears to me. But this, till now, from 1991 to 2020, this first challenge to the Places of Worship Act came about. This writ was filed. At that time, I had done this research, and I actually found only 10 or 15 reported judgments on this act. And they were all very small orders. This is barred, and so we are throwing the suit out. This is barred, like these kind of orders.
So you mean to say in the past there have been orders,
but in 1991 till 2020,
but there have been orders dealing with the Places of Worship Act,
but they have not really gone into this interpretation, but because it was so black and white.
That is how it was interpreted.
It was always
black and white, right?
So ASI, so that's what I was coming to. This ASI exception was never covered in any of these cases. It never came about. Interpretation of these clauses has never become the subject matter of any dispute till
Yeah,
now.
It's like a very neglected provision so far.
I mean, I think as a nation we'll be happier if it remains
Yeah.
neglected in the sense that it never comes to court. We never have to,
or maybe
face these disputes.
these issues were never raised in the past, right?
Never, no occasion arose is what I'm saying.
Right.
If you see, even if some like smaller acts also which are come later, I mean, at least in a year they'll have 10 cases. Not in 10 years they will have 10 or 15 cases.
Got it.
That's
Got
what I'm
it.
saying. So it was a non-issue. I don't think that there were any such, forcible conversion of religious places happening at that point of time. And that is when no occasion arose for, interpretation of these clauses.
Right.
So,
So you were mentioning areas covered briefly. So do you mean that if exploration is done and they do find maybe some deities somewhere or some, I don't know, inside the mosque, some sort of symbols inside the mosque, those will be protected by the law as well? Is that an argument that you're seeing playing out?
See, right now that's what the court has done, but it's an interim order. They have not decided the rights of the parties in this, and in fact, they have moved that 2020 suit to the district judge, and they've asked him to decide 7/11, which is already rejected, and the challenge is before the High Court. So, I mean, we will really need to wait and watch what happens. Actually, we will really need to wait and watch on this. That if they'll protect, or because if they if they find something under the sanctum sanctorium, then that will essentially be conversion of a place of worship. But as it stands today, you cannot convert what happened on 15th August 1947 is the cutoff date, and you shouldn't.
Okay.
But now we also have a batch of petitions pending in the Supreme Court challenging the Places of Worship Act.
Yes.
So how do you see this entire thing being played out? Because as you mentioned yourself that, the Aodha Judgment had dedicated a huge chapter or a huge section on the law, giving it support in a way so that, cases like Babri Masjid, Ram Janmabhoomi Babri Masjid do not get repeated, right? And it was equated to the basic structure doctrine as well. But now we are seeing a new chapter being written altogether with these petitions pending in the Supreme Court against the Places of Worship Act.
Yes.
So as far as these petitioners are concerned, what they say is that this act actually violates my fundamental right to go and worship, at a religious place, which I think belongs to my community, right? So what is your take on this entire?
And if you could also maybe elaborate a bit on what the petitioners
prayers
argue
are,
in the court?
So the petitioner's basic prayer is that, basic contentions are that their remedy, they have a right because their place of worship has been encroached and their remedy has been barred. Yeah. So where there's a right, there's a remedy. There's a maxim in law called ubi jus ibi remedium. So they say that, I have a right and my right has been barred. You have taken away my right to approach the courts, which is again violative of basic structure. How can you take away my right to approach the courts? Then they say that you have taken away my right to administer my religious place. So that is a violative of 25-26. Then another interesting argument that they make is in relation to the Waqf Act. So the Waqf Act allows Waqf boards or whoever to claim the Waqf properties, and limitation is not applicable to such claims. Yeah. And so they say that over there, they can claim their Waqfs without any limitation. And for me, you put a cutoff date of 15th August 1947. So these are their basic contentions. And of course, they want this act to be struck down. Now, if you ask me my personal opinion, I feel that we're at a moment that we don't know where to stop. We are going backwards, but we don't know where to stop. Do we stop at the medieval age? Yeah. And it's not only about Hindus and Muslims. There were so many Buddhist viharas which were actually demolished, and demolished by even some Hindu rulers. So, we need to take stock and see that, where are we going and where to stop. That way we'll, India is a very culturally rich nation, so to say. If we dig up probably, any place, any private, you will find something or the other. Right. So, we need to know where to stop, and that is the question we should be asking. When these petitions will come up, this is the question which the court will have to decide. And in fact, I want to add to this that these petitions have challenged the Places of Worship Act. There's another petition which has been filed for its enforcement, by the way.
Yes.
Yeah. So they have actually in their petition stated that, like you said, that, everywhere there's been orders being passed for, survey and so to say. And all of these plains, if you see, it's very like the Ayodhya matter. They'll have a deity, they'll have and they'll have a Swayambhu land. Yeah. And they'll have some people asking for the land, they'll have some people asking for the right to worship, which was also the case in Ayodhya. And Dr. Rajiv Dhawan's worst fears have come true actually. So that case says that you must have some guidelines to, direct these people as to when to actually exercise this power of, in every case, mechanically the case is being filed, next day survey is being ordered. So that is also a petition which is pending before the court. Notice has also been issued in that petition.
Okay.
I just want to know one thing, that to what extent would the observations made in the Ayodhya case have a bearing on this current case where this law is under challenge? Would it have a bearing or not? Because it's, after all, it was a 5-judge bench.
It was a 5-judge bench. It was a constitution bench. However, orally, the side challenging the Places of Worship Act, these people have actually already said that, those were obiter. Obiter is basically an observation on something which was not an issue in that case. But, I think the judges over there were very clever. What they did, after listing down all the issues, they say that this is something which traverses the gamut of the entire case. So even though technically they were deciding something which was accepted under the act, it was falling within the exceptions, but they've specifically made that line so that tomorrow if someone says that it is, an obiter, the other party can stand up and say that, see, 5 judges when said that this is so important, this needs to be decided first, then only we can go to decide the issues. So these are all arguments, I think. You can make arguments on both sides. We have to ultimately wait and watch what the court decides.
With this, we've reached the end of this episode. We spoke about Places of Worship Act 1991, an act which was brought about with the politicians saying never again. Like our guest Akriti said again and again, we had the Aodha Judgment with the judges hoping that this doesn't happen ever again. But we've had orders from various district courts across the country utilizing the exceptions under the law, which was so far sort of neglected. We do have petitions pending in the Supreme Court challenging the validity of the law, as well as asking for, on the other hand, enforcement of this law with a stronger hand. And like Akriti said, we'll just have to wait and see what the court says about it. Maybe the court upholds it or strikes it down, but in any case, it would sort of provide some sort of clarification on the grayer areas that have now cropped up so many years after the law was brought in. Thank you so much for watching this episode. Do let us know in the comment section what you thought about this. And like I always say, in case you have any law that you would like us to take up or discuss, do let us know in the comment section. We read all your comments. Thank you so much for joining us.